Okay, so we're starting with bankruptcy. This is chapter 21. This is the fifth chapter in our second unit. So this is the final chapter that we'll have. We'll be tested on later this week. So that will include 13 and 14, your formation and performance of sale and lease transactions under the UCC. Article 2. And then we've got your secured transactions chapters 19 and 20. Okay, so let's get into it. Let's talk a little bit about federal court structure, right? So this should be a review from 2080. And so in the federal court system, the court of original jurisdiction are courts where trials are held, and typically all trials. There's a few exceptions that we'll get to, but virtually all trials take place in the United States District Court. All right, and there is one in Cincinnati, District Court, for I believe it's the Southern District of Ohio is what it's called. You also learned in 2080 that there is always an appeal of right. And in the federal system, that is to the United States Circuit Court of Appeals. All right, and there are 13 federal circuits. The fifth is Ohio, Kentucky, and Tennessee. And also, the Fifth Circuit Court of Appeals is also in Cincinnati. So, I'm not sure, they may even be in the same building. They're downtown. But this is your appeal of right. Now, of course, on appeal, the appellate court only looks at questions of law as opposed to questions of fact. So it's very, very difficult to appeal questions, judges or jury's interpretations of fact at the lower level. That's really for questions of law. All right. The next appellate level is to the United States Supreme Court. Right, rest in peace, Ruth Bader Ginsburg. This appeal is not of right. The Supreme Court has the option to hear your appeal if you appeal from your Circuit Court of Appeals. And to be quite frank, most of the cases that they take are cases where one circuit, say the Fifth Circuit in Cincinnati, has decided one way, and the Sixth Circuit has decided another way on very similar issues, and you've got what we call a split amongst the circuits. That makes an issue ripe for Supreme Court acceptance. All right. It is also worth noting that the United States Supreme Court can hold trials in limited circumstances, and the biggest example is when one state sues another. Right, so Georgia happens to be a very litigious state. They've sued Tennessee and Alabama, and I believe Florida of late. Right, and that the only place that trial can be held is in the United States Supreme Court. All right, so that's your quick fly through of the federal system. Right, but when we're talking about bankruptcy, there is a bankruptcy court. Right, which is a court of limited jurisdiction, right? So district court is a court of original jurisdiction, but also a court of general jurisdiction, which means it can hear any type of claim. Whereas bankruptcy court is still in the federal system, has appointed judges. They're not life judges. They work for 14 years. They're appointed for 14 years. And this is where bankruptcy starts. So what we're talking about in this chapter takes place in this court of limited jurisdiction. There are a few other courts of limited jurisdiction in the federal system, namely tax court. But this is how it works. So if I want to appeal something from my bankruptcy court, the appeal actually is to the United States District Court. All right. Which is interesting. So, and not only is the United States District Court a court of original jurisdiction, a court of general jurisdiction, it also is for bankruptcy cases a court of appellate jurisdiction as well. Okay. Anyway, let's press on. So, if you study constitutional law, you learn relatively quickly that essentially federal law is enumerated, which means that the federal government can do what the Constitution says it can do, and everything else, kind of the default powers, and the much bigger piece of the pie is state law. Right? That's why most cases that if you look at the volume of cases, most court cases are handled by the state court system. All right? The reason that bankruptcy is explicitly federal, well, it came over on the Mayflower, so to speak. So in England, there were debtors' prisons, which means that if you couldn't pay your bills, you went to jail. All right? And if you've ever heard the term Judgment Day, most people think it's the biblical sense or the pearly gates. That's not accurate. The term Judgment Day relates to the day in which your court date after you failed to pay one of your creditors, and you would be judged to prison. All right. Well, early settlers didn't want that. They didn't agree with that. So they wrote into the Constitution that bankruptcy is explicitly federal, which means the states do not have the right to govern bankruptcy except certain places like state exemptions, where we'll have a bit of a dialogue later in the lecture. But that's only because it's actually written into the federal law that states can articulate their own exemptions. So why was this? The big idea was that should you go to jail for being unable to pay your bills, the framers thought not. You should be able to get a fresh start. Right? And also, the second articulated goal of bankruptcy law, fair treatment for creditors. If I have more debt than I have money to pay, is it equitable? Is it fair for me to pay one creditor, either the creditor that I like the most or the creditor that I'm relying on for future business or what have you, at the expense of all of the other creditors? And the answer is no. So the bankruptcy system is designed to protect the creditors, or it should say not protect, but to ensure, well, I guess it is protection, ensuring a fair treatment of creditors. Okay. So there are four main flavors of bankruptcy. There are a few others that we won't get to. There's one for municipalities that we won't talk about. But Chapter 7, which is liquidation, it's available to individuals and businesses. If you liquidate a business, the business typically is out of business. All right. Chapter 11 is reorganization, which allows the business to continue to operate. All right. Some debts are typically discharged and restructured, and then the business lives to transact another day. Chapter 12. And so when you study federal law, you find many places where there is favorable treatment for farms. And the bankruptcy code is one such of those areas. So Chapter 12 is the most favorable chapter, and it is only available to farmers and fishermen, family-owned farms and fishermen. that doesn't necessarily mean small businesses. We'll get to the definition of what a family-owned farm or fisherman is. But by and large, I mean, it's actually quite simple. I mean, they're entities that derive more than half of their revenue from farming or fishing. All right. And the idea here is protection of the food supply, whether you agree with it or not. That is why Chapter 12 exists, and it is more favorable than the other terms. And of course, Chapter 13 is reorganization, which, similar to Chapter 11, it does not discharge all debts at the end of the process. So you still have to pay debts. They may be reduced in some cases, but that's the idea with reorganization. So it gives the debtor room to breathe, but you still have to pay a chunk of the debt.